This is part 3 of a 3-part video series on challenging and how to contest a will, trust, power of attorney. In our prior 2 videos, we talked about the general criteria of under which one can challenge each of those 3 types of bequests. One point I want to really emphasize to our viewers is that many times the challenges are brought by close family members who were disinherited or left out of the will or trust. Oftentimes the person who is the beneficiary is someone who was very close to and was in a superior position, either by way of residence with the person or caregiving, but in some manner achieved a very close relationship with the maker of the will or the trust or the power of attorney. And because of that close confidential relationship, they were able to achieve a greater economic benefit from it. One point that we've talked about in several prior videos is that all of us who are representatives of the elderly have a fiduciary obligation. We are stewards of that person's resources and funds, and we do not have an absolute right to benefit to the exclusion of others. But if you believe that the circumstances under which a parent's will or a sibling's will or a friend's will or a domestic partner's will were changed materially for reasons that are illegal, you need to take action, because under New Jersey law there is only a certain limited period of time to contest a will in a process known as a will contest or probate dispute. If it involves a trust, one has to immediately go to court to obtain an injunction against the trustee, because unlike wills, trusts are not subject to New Jersey probate and therefore do not have judicial supervision to their ongoing administration. So if you are a beneficiary or you've been left out of a trust or your bequest has been substantially reduced, you need to seek legal assistance immediately so that your attorney can go to court. As relates to powers of attorney, those are the most dangerous. With the power of attorney, the agent has the authority to act as the representative of the principal and has the authority to immediately take action to deplete that person's resources. Again, legally they're fiduciary, but oftentimes because of the relationship, the power of attorney does things which are either A, illegal, B, fraudulent, or 3, contrary to the intentions. And if the person who gave the power of attorney was vulnerable, if they're aged, if they were dependent on the power of attorney, threatened by the power of attorney, that if they didn't provide the document to them, they would be thrown out or not cared for or left destitute, those are circumstances under which the family needs to take immediate action, or someone who is in a close relationship or cares about that person needs to take immediate action. There are agencies in the state of New Jersey. Each county has a department or an office of aging. There's adult protective services. There's the state ombudsman. Those are agencies which were implemented to protect the elderly. But when the resources have been spent, misappropriated, it's too late at that point in time. So take action immediately. If you want to speak to me, my contact information is on the screen. It's a toll-free number. You can email me. We have many qualified people here who can assist you, including myself, and don't hesitate to contact us. We're going to talk next about elder abuse and elder exploitation. It fits very closely to the subject matter of these tapes, and I think you'll find those to be of interest as well.